They will each talk for about 15-20 minutes. I'll pose some questions to them, and then we'll open it up for the audience. So, just the topic for today is about IP rhetoric, piracy rhetoric, and the rule of law. Basically, with technological change over the last 2 decades, the intellectual property wars erupted. In the past, it used to be that if you wanted to copy something, you really had to have a printing press at your disposal. Now it's much easier to do that. You can just copy software, you can copy music, you can copy a film. Now, this gave rise to heated wars. Some advocate strong intellectual property rights and argue that copying music, copying software, movies is copyright infringement. And some of the most famous patents surrounded the famous file sharing systems like Napster or Rockstar. Now, in every war, there's ammunition, and a big part of the ammunition in this war was the rhetoric which is being used. So I want to show you some examples of the rhetoric before we start. So you've probably seen this around, but now you can read it more carefully. So this cost $14.99. This could cost you $2,000 because you could be fined and go to prison. And if you notice in the right-hand bottom corner, it says piracy is theft. This is very common rhetoric. Another example, the one on the right is handling stolen goods, to make you understand that copying software is also stealing. And again, you see the common, the right hand at the bottom, piracy is theft. Piracy kills music. You're killing the music industry by copying music. And this is more sophisticated. Here showing that suppliers are pirates, facilitators like internet directories are pirates, but also the common person is a pirate. That you, by individually copying, you are participating in this hierarchy of piracy. So these are just some examples, so you see the rhetoric that our panelists are going to discuss. And really the big question for this debate today is, does this rhetoric undermine the rule of law? Is calling individual people, calling them pirates, calling them thieves, does this reduce the effectiveness of other legal sanctions where theft might be much larger? For example, if I download music, now I'm a thief, and I'm getting used to the idea, maybe I won't be so afraid to embezzle because I'm already a thief. So these are some of the questions that our panelists are going to address. So now I'd like to introduce the panelists. Our first, known to many of you, is Professor David Opderbeck, who writes and teaches in the area of intellectual property. And I think especially relevant to this talk, he wrote about peer-to-peer networks. Our second panelist is Adam Mossoff. We're very happy Professor Mossoff joined us from George Mason, and he writes about the intersections between property and intellectual property, with a special focus on the intellectual property of protected history of patents. And he taught in the area of patent law, property, and cyber law. Which reminds me, because I mentioned patents now, that this rhetoric is also used in the arena of patents, i.e., when third world countries you can't afford patented medicine, they produce the same medicine in India without paying patent holders, they are also called pirates. So this rhetoric is more widespread than the examples of copyright. Okay, so we're going to start with, who's going first?
I'm going first? Sure.
Okay.
All right. I think I'll use the podium because we'll use anyone we change that. Yeah, you just go back to put that back to the. I don't know, I kind of like this. I don't know where your original. It's still open. Ah, there we go. Okay. Well, sorry about that. I actually want to start my part of my presentation with a quote from an article I saw in The Economist about a month ago. that doesn't really relate to intellectual property, but I hope you'll see how I think it relates to the theme of our debate. So here's a quote from this thing I saw in The Economist. In some settings, light green slacks would merely be a fashion crime. In Sudan, they actually may be against the law. Lubna Hussein faces 40 lashes and an unlimited fine if she's convicted of being inappropriately dressed in public for wearing those slacks. She was arrested a month ago under Article 152 of Sudan's criminal law, which forbids indecent clothing in public, without specifying exactly what that means. According to Ms. Hussein, 10 of 12 women arrested with her immediately accepted that they had been improperly dressed. They each got 10 lashes and paid a fine equivalent to $100. Now, why am I telling that story? It's obviously a pretty extreme story, and I think for most of us, it hits us as somewhat shocking, that punishment. Even if we were to somehow agree that in some cultures maybe that have modesty laws, that it's maybe not good to violate those laws, that punishment is kind of extreme and serves to undermine, even at the end of the day, those laws. A couple of other little examples. A Boston University graduate student admits to downloading and distributing 30 copyrighted music files. The jury assesses $675,000 in damages. Jamie Thomas Rassett, a 32-year-old single mother of 4 children, is found liable for illegally downloading and sharing 24 copyrighted music files. I have here a little description from someone who was there about what happened at her trial. Email addresses, her phone number, a floor plan of her apartment, her Match.com account, her Best Buy purchase history, screenshots of her Windows PC, all of it displayed on flat panel screens, blown up for and scrutinized by the jury. Her ex-boyfriend on the witness stand, discussions about her education, career, and CD collection, and experts sifting through her hard drive. And at the end of that trial, the jury assesses $1.92 million in damages. A third example I'll point out is the Doha Declaration under the TRIPS agreement, which relates to patents. It's an international treaty that relates to patents, says that developing countries under some circumstances can issue compulsory licenses in order to get patented medications for a lower price. Thailand takes advantage of this provision, issues compulsory licenses on AIDS drugs and some cardiovascular drugs. The response of the United States, at the behest of the pharmaceutical industry, is to place Thailand on its intellectual property priority watch list. Well, I think all of these examples illustrate that the rhetoric in the intellectual property war has ratcheted up the results of the intellectual property war. Now, I'm not going to try and defend Jamie Rassett. I'm not going to try and defend the Boston University student in terms of saying that, sure, they should be able to just download copyrighted music and share it. And if you look into the details of the trial, you can see, well, they had some problems with some of their testimony and things like that. But in my view, the rhetoric that's being used and the amount of the awards are excessive. Now, don't get me wrong, I think intellectual property rights are important. And I think there are a couple of important justifications for intellectual property. I tend toward the sort of pragmatic utilitarian justification for intellectual property. So I might talk about the Coase theorem. I might say that, yes, sometimes it's important to put fences around things and to call them property rights so that we can facilitate exchange. I'm also not averse to Professor Mossoff's view that intellectual property has some roots in natural law theory. Yes, I can see in the history of intellectual property that Lockean-type labor theories have been used to say you put labor into a state of nature and then you're entitled to some reward for that. So I can see both of these streams, and we could have an interesting conversation about exactly how those streams play out and come together in the law. But for this purpose, I think the important thing to remember is that both streams carry with them very important limitations. In neither case is intellectual property or any property right absolute. So if we think of the sort of economic stream, Coasean theory, we can talk about, well, if this is going to work, we have to have a situation where we have relatively low transaction costs, relatively low information costs, and relatively few externalities. And there's a significant literature about whether intellectual property fences have gotten too high and are too far out to the point where now they impose significantly greater costs than they should. From a natural law perspective, now we could have a really long and interesting, we probably could spend the whole semester talking about the various views on what Locke's labor theory actually means. And believe it or not, there are multiple schools of exegesis of Locke. In my view, there are at least 3 conditions for Locke that limit the scope of a property right. One of them is a spoliation condition. You can use as much, you can appropriate as much from nature until it spoils. So if you're putting labor into nature and you're growing crops, for example, yes, you have a property right in those crops, but it doesn't mean that you can just leave those crops on the field to spoil. Your right doesn't extend that far. Another important one is the enough and as good provision. Yes, you can take from nature, you can add labor to nature, and you can have a property right in that, but you need to be enough and as good for others to use. A third one is the very notion that you have to actually add labor. You have a natural right in the labor that you add. Now, all of these theories are inherent in Locke. They're also inherent in the common law, I would suggest, even the basic common law of property. So if we think of real property, you can think of limitations like nuisance law. You can think of limitations like easements. All of these things are trying to balance what is the scope of this right. Now, I want to suggest that intellectual property law, whether we look at it from a natural law or an economic perspective, has inherently built into it, through the wisdom of the people who initially built these rules, these sorts of limitations. I think the history of both copyright and patent policy in the United States is one of trying to find this balance. In the area of copyright, there's some really interesting historical work. I'll just mention a few things from an article by Joyce and Patterson. Just a couple of quotes from their paper, kind of going through the history of the English copyright law as it leads to the American copyright law. They suggest that the original stationer's privileges in England were primarily for the purpose of censorship and control. And what they say is that the statute of Anne, the copyright statute that then shifts copyright to authors rather than to the publishers, transforms copyright from a plenary property right that could inhibit learning into a limited property right that promotes learning. They say the revolutionary feature of the statute of Anne was the creation of a public domain for literature, a complete repudiation of the policy of press control. I think we can say similar things about patent law. We can see it inherently in the requirements for obtaining a patent, novelty and non-obviousness, and how those doctrines have developed. We can see it in the ability to enforce a patent, the rules about claim construction, the limitations on the doctrine of equivalence, how those rules developed. We can also see it, I think, in important ideas that work their way very significantly into the international IP system, especially compulsory licensing. So there has always been in the jurisprudence an idea that under some circumstances the public has a right to take a license to a patent. And that finds its way into the TRIPS agreement and the Doha Declaration, as I mentioned it. You also see in some, not so much in the United States, but in the patent jurisprudence of other European countries, working requirements. And ideas that, yes, you have a certain kind of right to obtain a patent on your invention, but you can't just have that right and put it on the shelf. You have to work that and use that invention in some kind of productive way. I think we might say, if we want to put that in Lockean terms, that spoliation provision comes into play there, and that enough and as good provision also comes into play. So I want to say that in economic terms, if the IP fences are too high and too strong, we increase costs. People start to try to avoid those rules, and I would say this not just with IP rules, but with any legal rule. We have things that economists call aversion costs and avoidance costs. Tim Wu, who writes in the area of intellectual property, kind of puts this together when it comes to music file sharing, and calls them avoidance costs. So we put these costs together, and the fact is, the rules are so extreme that people need to find ways to get around them, and that imposes costs. But even more so, I would say that when the fences are too high and they're too far out, that imposes a moral cost. And this tradition, I think, goes way, way back in Western jurisprudence. Let me read you a few more quotes. St. Augustine, an unjust law is no law at all. St. Augustine again, in the absence of justice, what is sovereignty but organized robbery? Aquinas, Thomas Aquinas, in human affairs, something is said to be just, insofar as it is right, according to the rule of reason. The first rule of reason is, however, natural law, thus every human law has the nature of a law insofar as it is derived from natural law. If it conflicts with natural law in any way, then it's not a law, but a corruption of law. Sir Edward Coke, 17th century, when an act of parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it, and a judge such act to be void. So we have, even in sort of moral natural law theories of what law is all about, this important counterbalance that if the law has become too extreme, if it's impossible for people to perform the law, if the law is contrary to practical reason, if the law is contrary to the moral sense of justice, then it's really not valid law. And if we try to keep that law in place, we'll actually end up undermining the rule of law. A great example of how this works is Soviet economies, communist economies. There's a bunch of studies that have been done that show that the black market, the underground economy developed. Why? It developed because the legal economy was so heavily regulated that nobody could even keep track of all these regulations. What did that provide? It provided opportunity for fraud, it provided opportunity for graft, and it facilitated a black market underground economy that ultimately undermines the very rule of law. We have some analogies for this today, don't we? We can think about prohibition on alcohol or prohibition. Some people will talk about the war on drugs. We can talk about things like overly restrictive traffic speed limits, which nobody observes. We can talk about perhaps regulation of tobacco. I have an interesting quote here from the Cato Institute on the tobacco wars. The war on cigarettes, like other crusades, may be well-intentioned at the beginning, but as zealotry takes hold, the regulations become foolish and ultimately destructive. Consider the provisions in the current bill that would grant FDA control over tobacco advertising. Not only are the public policy implications harmful, but there are obvious First Amendment violations that should concern every American. I think, now I won't take a position here on how we should regulate tobacco or not, but this same sort of underlying concern I think is an important one that spills over into intellectual property. A great example of real, practical, real-world example of how this happens is in the kinds of new regulation that we're enacting, not only to protect the property or privilege of the intellectual property right, but to keep anyone from even touching fences that guard those rights. And I'm talking here about the Digital Millennium Copyright Act. So now not only is it unlawful to make an illegal copy of a music file, but if the music file is protected by some kind of encryption, you can't even mess with the encryption. And that is sort of a new kind of super copyright right. Another interesting quote from the Cato Institute on that. As Robert Frost wrote, good fences make good neighbors, fences demarcate property lines, no one would dispute that fences are valuable, yet Congress would be rightly ridiculed if it made it a crime to hop over a fence. Sometimes hopping a fence is unobjectionable. When you lose a baseball on your neighbor's property, you see a stolen bicycle in someone's yard, or you know a lot has been abandoned, for example. And these laws, it goes on to say these laws would be completely unnecessary because the common law already protects the basic property right. Well, I'll tie this into a quote from a somewhat disparate source, which is Lawrence Lessig. So Lessig writes about in his book, Free Culture, he writes about intellectual property law and how, in his view, intellectual property laws become too restrictive. Here's one thing he says. Overregulation corrupts citizens and weakens the rule of law. The war that's being waged today is a war of prohibition. As with every war of prohibitions targeted against the behavior of a large number of citizens, the rule of law depends on people obeying the law when 40 to 60 million Americans are considered criminals under the law, and when the law could achieve the same objective, securing rights to authors without these millions being considered criminals. Who is the villain? So I think Lessig asks a very, very good question here. In some of my own work, Professor Bernstein mentioned a paper that I had published on peer-to-peer file sharing. I have some empirical data in that paper. We can have all kinds of debates about the data and how useful it is. But in my view, it shows that what happens when the recording industry brings these lawsuits against individuals and pushes this war against piracy isn't that people stop being pirates. It's that people move to less and less centralized networks. They move around. And in fact, probably the overall level of piracy increases. What does it do? It creates a class of outlaws who are now, just like in Soviet Russia, forced to engage in some kind of black market economy. Instead of having a rational rule in which there could be proper compensation to the creators, to the authors, to the people who actually put some labor into the state of nature, while leaving enough in as good for others, while not leaving things spoiled, and while not creating all of these costs through these intermediaries who aren't even really the original creators. I could say a similar thing, and I've said similar things in my work about patents. So I've tried to provide some empirical models in my patents in my articles on patents that show that the pharmaceutical companies that are doing the research and development and creating these drugs have more than adequate remuneration for their efforts if they're able to have reasonably strong patents in developed countries where the elasticity of demand is such that they can charge certain prices for those drugs. They don't need strong patents in developing countries where the elasticity of demand is such that they really can't charge very high prices for those drugs in any event. So again, if I take an economic perspective, I can say that rule seems irrational to me. If I take an Augustinian or a Thomistic or even a Lockean perspective, I could say it seems to me that the person who's putting in some labor is trying to take more than the labor that they put in. They're not willing to leave as good and enough for others. And they're willing to allow some of the fruits of their labor to simply spoil rather than facilitating the public domain. So my conclusion is not that we should do away with intellectual property, is not that we shouldn't explore all the different rationales for why we have intellectual property, but that at this point in history, the rhetoric and the kind of enforcement and the lobbying and the regulatory capture that seems to me to be happening has gotten way out of proportion and has the effect of undermining the important values that we do want intellectual property rights to serve. Thanks.
Thank you. All of you will be clapping to the end, but everybody in the back, why don't you come and sit up front? Lots of seats available.
Lots more stand.
Yeah.
Hello, I'm Professor Mossoff, and I'm defending, given that I'm defending the property status of intellectual property and use of property type rhetoric and piracy, I think I can probably most efficiently and better end this debate right now. David? I find your lack of faith disturbing. Oh, it's not working. All right, I guess I'll make my arguments. All right, so look, I think you got from Professor Opderbeck an excellent presentation of what is today the convention of wisdom. I very much appreciate his invocation of Locke. I rarely go anywhere without my copy of the two treatises. And I'm glad to see that he's at least coming around somewhat to lock in arguments. But I also think Professor Opderbeck presents the conventional wisdom that for many people, the unauthorized copying or use of someone else's book or invention is piracy, if at all, by analogy. Right? A lot of people think of this term as largely a rhetorical epithet, one that's used by intellectual property owners to paint peer-to-peer file sharers and others in simply a bad light. Right? The argument by bloggers and by scholars like Larry Lessig, who wrote in defense of piracy in the Wall Street Journal about a year ago, is that IP owners are really just trying to make an emotional or visceral connection between this classic image of a dastardly pirate on the high seas, stealing booty, and some young mother or some college student who's taking the profit from an artist or inventor, or as they frame it, the recording industry or big bad pharmaceutical company. People criticize the use of this property rhetoric in discussing copyright or other IP issues. They see it as part of a modern political agenda of the industry. And even a lot of people, even scholars and bloggers and policy analysts alike, even claim that the term intellectual property itself is a relatively modern phenomenon, that it didn't even come into usage until relatively recently in the late 20th century. All of these claims, I maintain, big surprise given my status in this debate, are wrong, both as a matter of history and as a matter of theory. As a historical matter, property, the framing of intellectual property in property terms, both copyright and patent, is long-standing, reaching all the way back to the 18th century. Justin Hughes, I do most of my work in patent law, where I've gone back and looked at the historical record. I've read all 1,400 patent decisions from the 19th century. I've read legislative debates and pamphlets. And what I found was an overwhelming use of not just property concepts by judges and lawyers and others, but also property rhetoric. And I'm not talking like small guy judges. I'm talking about like little-known justices like Chief Justice Marshall, maybe you've heard of him, Justice Story, saying that the infringement is piracy. Saying this is as late as the 18-teens, 18-aughts, and upwards. Now, this is a highly contestable claim today. So why did they think that intellectual property was property back in the 18th and 19th centuries and felt free to use property rhetoric in the way that they did? Well, the answer is that they thought that intellectual property at root was, in fact, property. Now, all too often today, the debates are over conclusions, right? Piracy versus freedom to innovate, or piracy versus the use of piracy rhetoric versus other social norms rhetoric. But from my perspective, this is a lot like debating a court decision, saying like a defendant is liable for trespassing without paying much attention to the reasoning or the holding underlying the decision. Piracy is a conclusion. It's a conclusion. It's a rhetorical conclusion. But what makes that conclusion make sense, if it does at all, is what's the meaning of property that justifies the use of terms like theft and piracy in the intellectual property context. And that's the $64,000 question. What is the meaning of property that makes intellectual property infringement a type of theft? And when it's done deliberately and intentionally, like the young woman and young mother in Minnesota, as was proven at trial, as well as the Boston student Tenenbaum from a few weeks ago, but I understand said, yes, I knowingly copied music. I downloaded it. I know it was a copyright violation. When you knowingly steal, we call that piracy. The $64,000 question is, what's the concept of property that makes that conclusion possible? Actually, I'm dating myself. I really should say $64 trillion question. So, the understanding again here is what is property that makes intellectual property a property that makes its infringement a type of theft in deliberate cases of piracy. So that's going to be the structure of my remarks. We first be talking about what's property, then talking about why early American judges and legislators thought that intellectual property was in fact property given the dominant conception of property at that time. And then third, I'm going to actually detail some real-world results in legal doctrine and show actually how the framing of intellectual property as property rights and the use of property rhetoric actually led to the creation of legal doctrines in American IP law that furthered the rule of law with respect to IP. And the United States was, in fact, a vanguard in this respect with respect to the protection of intellectual property in the 19th century. As an aside, I just want to emphasize, I'm going to be talking about patent law as that's the area of my focus of my work, but other people who do copyright, like Justin Hughes at Cardozo, published an article in the Southern California Law Review a few years ago on the use of property in piracy rhetoric in copyright, showing it goes all the way back to the 17th and 18th centuries, have done work in other areas. All right, so let's begin. And to continue kind of my reference to one of my favorite pieces of intellectual property until it's been destroyed by its creator, I need to take you all to a galaxy far, far away. Time long, long ago. 18th and 19th centuries. Founding in antebellum eras. At that time, dominant property theory was provided by natural rights philosophy, or what we now refer to in shorthand terms, Lockean conception of property. The idea of property securing rights to acquire, use, and dispose of one's possessions. The legislators and judges in the American IP system use this theory of property in creating the American patent system, securing to inventors their property rights in their inventions. Thus, the first 4 iterations of the patent statute, 1790, 93, 1836, and 1870, all explicitly secure to inventors the, quote, exclusive rights to manufacture, use, and sell one's invention, unquote. Substantive rights of acquisition, use, and disposal. Why? Why did they secure these rights to inventors, patentees? Key is understanding Locke's labor theory, specifically his mixing labor argument. Now, this is pretty well known today. I'm sure all of you have read selections from the second treatise, or actually have read the entire text. I'll assume that you know in chapter 5 of the second treatise, Locke says a person mixes one's labor with something in the world. This creates a moral claim to that thing, and that moral claim is secured as a right to property. Now, this is widely criticized today. People say, well, prominent philosophers, German Waldron, say you can't mix labor with something in the world. Labor is an action, a thing in the world is a thing. Actions don't mix with things. It's what philosophers call a category mistake. And literally, they say, Locke he must be confused. He must have been smoking something when he wrote this. But I maintain that this criticism of the mixing labor argument is a misunderstanding of what Locke was talking about when he said mixing labor. For Locke, mixing labor was not meant to be taken literally. It was a poetic metaphor for him. It was taking some license with what he meant to identify, which is productive activities that create new values for people by which they can live. Now, if you look at every single example that he gives in chapter 5 of what he means by mixing labor, they all are examples of productive actions, someone producing something. Here they are. Gathering nuts, growing vegetables and fruits, mining ore, drawing water, killing a deer, catching fish, hunting rabbits, cultivating land for farming, sewing clothes, baking bread, cutting down timber, and perhaps the most important for lawyers, law students, fermenting wine. Locke writes in the second treatise, quote, nature and the earth furnish only the almost worthless materials, unquote, and it is these that, quote, industry made use of in creating all manner of items used by God, or by people. Or as he says elsewhere, I'm sorry, I didn't mix my quotes, quote, God gave the world to the use of the industrious and rational, not to the fancy or covetous, wholesome and contentious. Now, why is it important to understand that mixing labor means production? Well, it's important because this has 2 important results. First, it situates the right to property within Locke's ethical theory, a natural law ethical theory, which begins with a primary moral obligation. One must preserve oneself. And as moral philosophers happen to say, ought implies can. If you ought to do something, you can do it. And thus the only way for humanity to preserve itself is for people to produce the objects they need to survive. You don't go out into the forest and find clothing, condos, cars, air conditioners. These things have to be created. They have to be thought of and identified and created. Thus, production within Locke's normative theory is a normally justified value-creating activity that maintains human life. Secondly, the second reason why it's important to recognize that mixing labor means production is it explains why Locke is so interested in proving the labor theory of value as part of his justification for property. This is a mystery to a lot of people, but it's because for Locke, property arises from the creation of new values: food, clothing, shelter. These values arise from productive activities, and thus the results of these productive activities, these new values, are the property of their creator. Now, this was widely understood and embraced in the 18th and early 19th centuries. I can I could sit up here and quote from you nonstop, for my entire 15, 20 minutes, statements by the founders and judges and legislators, but I'll just give you one. And this is a short essay written by James Madison in 1793 in the National Gazette newspaper entitled Property, in which Madison announces that property in a strict legal sense refers to, quote, a man's land or merchandise or money. But that, quote, property has a larger and juster meaning, in which it embraces everything to which a man may attach a value and have a right. And in this larger sense, Madison continues, quote, a man has a property in his opinions, he has property in the safety and liberty of his person, and, quote, he may be equally said to have a property in his rights, end quote. Thus, property law secures the fruits of one's labors, meaning the values one creates through one's productive activities. And then the law secures these moral claims by securing the rights of use, enjoyment, and disposal of one's possession, the core rights of property. This is why Justice William Patterson wrote in Van Horn's Lessee v. Dorrance in 1798, quote, no man would become a member of a community in which he could not enjoy the fruits of his honest labor and industry. This was widely embraced, as I said, in the United States property law. In New Hampshire Supreme Court, for instance, declared, quote, to deprive one of the use of his land is depriving him of his land. For as Lord Coke said, what is land but the profits thereof? End quote. Okay? Or the Pennsylvania Supreme Court, quote, property without the power of use and disposition is an empty sack. Now, given this conceptual and normative focus of Lockean property theory on securing the use and disposal of the values one creates, its application to intellectual property was completely natural and logical for American politicians and lawyers. Because protecting patents under the law secures to inventors the fruits, their profits of their labors. And recall, Lord Coke even said, what is property in land but the profits therefrom? So for them, it was completely logical to connect this to inventions. And thus, they began the process of defining patents and copyrights and ultimately trade secrets and trademarks as property rights. Now, it bears emphasizing that this was a unique approach taken by the American legal system and politicians in the 18th and 19th century. Because in England and in the continent, patents and copyrights up to that time as well, or at least patents, I should emphasize patents, have largely been defined as personal privileges granted by the crown or the state. They were monopoly privileges according to a person, personal privilege. And yet, in the U.S. political system, and specifically in the courts in the early 19th century, they explicitly recognized that patents were not personal privileges granted by the state. They were property rights, tantamount to property rights the estates one has in land and personal chattels. And as a result of this, what followed were substantial institutional, doctrinal, and constitutional developments. Since U.S. patents were conceptualized in the same terms as common law property rights, for instance, patents were called title deeds. They applied property concepts in patent law cases. Multiple owners of patents were called tenants in common. Maybe bringing back some bad memories for some of you from your first year property class. Infringement of patent, very early on, very first patent cases was called trespass. This is trespassing on someone's rights. And legal disputes over patent licenses. Courts relied on and cited as determinative precedent real property cases at common law involving conveyances, easements, and restricted covenants to help decide the cases for them between a patentee and a licensee, or a licensee and an infringer. As a federal judge instructed a jury in an 1846 patent trial, quote, an inventor holds a property in his invention by as good a title as the farmer holds his farm and flock. As a result of the application to property concepts and normative justification for property at the time, patents, you can see what followed from this. They developed the conveyance doctrines, the licensing doctrines. They secured infringement as a type of trespass and called trespassers, these types of trespassers, pirates. As I indicated, Chief Justice Marshall, Justice Story, and other justices on the Supreme Court and lower federal courts repeatedly used this type of language in referring to infringers of patent rights. It even had a more important impact insofar as it led to the institutionalization of patents within the American system under the rule of law itself. In the antebellum era, Congress quickly moved to create the Patent Office. It issued patents under pre-existing legal rules set forth in statutes and in case law. This was unheard of in England and in the continent, where patents were issued at the prerogative of the Crown or the state. This was deemed to be something that was done solely at the discretion of the Crown. In other words, what was occurring in the United States in the 19th century was the federal government was replicating the title recordation and publication practices from real property law with respect to patents. Why were they doing this? Because they viewed patents as property rights. Same property rights in terms of concepts, doctrine, and normative rhetoric as real property. As Daniel Webster declared in a speech on the House floor in 1824 in introducing legislation to protect foreigners obtaining patents in the United States, quote, "The right of the inventor is a high property. It is the fruit of his mind. It belongs to him more than any other property, and he ought to be protected in the enjoyment of it," end quote. And thus it was clear to people like Webster and courts that the taking of these fruits, their profits, by citizens or the state was a type of theft. And when it was done deliberately and intentionally, it was, in fact, piracy. As a result, courts repeatedly applied the policy that the law should secure to patentees the fruits of their inventive labors, a phrase you find that runs throughout a lot of patent cases, meaning the law should secure to them their profits. And thus, it should be unsurprising that American courts very early on identified infringers as pirates, and that this reflected their commitment to protecting patents as property rights within both the institutional framework and legal doctrines that we would now look back upon and say are exemplars of the rule of law. Thank you.
Thank you. Again, people in the back, if you want to take seats, seats up front.
Force is strong.
Okay, so Professor Opderbeck, my first question is to you. You seem to mind privacy better in these areas which I think you believe are gray areas for enforcement of intellectual property rights. I wonder if you would remind this rhetoric so much if it was used in areas where you clearly think that there is an infringement. For example, there are two competitors, and one had an invention, they got a patent, and the second one clearly copied that invention and tried to market it. So we'd have clear patent infringement. Would you mind this rhetoric being used in this context?
Depends who I'm representing.
Yourself as a president.
First of all, I think I would probably push back against the idea that there's ever a case of clear patent infringement. Now, I suppose there are such cases, but quite often, I mean, the interesting cases, it's not always clear. I mean, one of the things about patents is that the patent, and I think this is one thing that, if it's something you want to call property, makes it a very unique kind of property, is that the right is probabilistic. It isn't that you have a deed that lays out metes and bounds and in advance where a surveyor has gone and laid out the metes and bounds, and the dispute about the actual metes and bounds is relatively rare unless there's some problem with the title, right? But the patent, the metes and bounds of a patent can't be determined until the patent is adjudicated. We need a Markman hearing. We need a decision from the court about what the claims mean. We need to know what the range of equivalence is. We need to know whether the patent is in fact valid, because it's presumptively valid, but that presumption is rebuttable. And in many cases, patents are found to be invalid. So I guess the first thing I would do is I'm not so comfortable saying that there are wide swaths of cases now being litigated in patents that the infringement is clear. And I guess the second part is, I do see this thread of these cases where courts are using this language. But I think even under a Lockean approach to property, it isn't true that any impingement on the property right is theft or piracy. So, and you know, as I tried to mention in my talk, there are all sorts of rules that that are designed to balance out the concerns about public access, concerns about nuisance, all these other sorts of concerns, and those sorts of concerns are particularly important in intellectual property. Again, whether it's a natural law or an economic perspective that we're taking, because we have these concerns about free speech, and because constitutionally copyrights and patents are for limited terms, and the purpose of that is because ultimately this property returns to the public domain. So, you know, I'm not entirely comfortable with using this rhetoric at all. And I guess the last thing I would say is that it's hard for me to dissociate any use of this rhetoric from the current climate. I feel like the current climate has been poisoned by the intellectual property wars against the public. So if I were to look at this in a vacuum and say, well, okay, it's just some U.S. manufacturer whose product is being knocked off by a factory in China, and all they're doing is, you know, the company saying, here, copy this, and I've had clients who've done that. You know, okay, but because of the tenor of the rhetoric, it's almost like the marginal cost of this is making it difficult.
Okay. Professor Mossoff, your...
Well, I think
Sure.
I need to respond to this because he said a lot of things that are very contestable and debatable. One is that no clear case of infringement. There are clear cases of infringement all the time. I mean, in law school, we focus on the fuzzy cases. The fuzzy cases are fun. They're teaching. And there are lots of fuzzy cases. But there also are court cases. There are tons of court cases. Oftentimes, you don't see the court cases because they're a court case. But very oftentimes, there are the cases where they're court. The Massachusetts case, the guy got on the stand and said, I was infringing copyright. I knew I was infringing the copyrights. I think it was a clear case of intentional infringement by, his name is Henderson. Henderson?
Yeah, just to be clear, I was talking about patents where the...
Well, but even in patents, we have clear, there are cases where someone said, I copied your patent. I mean, that's a clear case. I copied the patent. I copied it. I mean, I don't think you could get any more clear than that.
Well, we all know that the patent's valid.
But also, I mean, the framing of probabilistic, this idea of probabilistic, I teach property, and I really have to contest this because I think scholars do this all the time. They make this empirical claim that there's clearly no disputes about boundaries in property law. So of course, you guys, when you took all your property class, there's only maybe one trespass case which you all read, right? Because there's no disputes, because everyone clearly knows where the boundaries of their states are, right? Of course not. There's disputes on boundaries all the time, both intentional and unintentional. More importantly, the boundaries of property law, as you guys learned in your Wendell property class, are not defined by the land. You learn that a property right is an estate. And the first thing you learn when you learn estates is that estates are not land. And so the boundaries of the property right are the boundaries of the dimension of time, scope, use. And so the boundaries of real estate are not defined by fences. That's one aspect. But it's also defined by nuisance. It's defined by easements. If you expand the scope of an easement, right, trespassing, yes, but that's a breach of a right to use, that's not a breach of the right to exclude as such. It's defined by the scope of the estate granted itself, life estates. Fee simple defeasibles. Are there tremendous disputes over these? What estate has this created? Is this a life estate or a fee simple? These are all disputes over what is the scope and boundaries of the property interest that's been created. And one could argue that, yeah, I have a deed, but the court has to determine the validity of this deed, just as in asserting that this is a life estate. In fact, there's litigation on this all the time. We have our equivalent to the Markman hearings in real property law, the interpretation and construction of conveyances. In fact, I'm doing estates right now with my students. My students are learning that, wow, someone thinks they can write a life estate, and they haven't created a life estate if they didn't use the proper words of limitation. I hope I'm not bringing back too much painful memories for you guys. Do you have the same, and even more interestingly enough, the presumption of validity for patents. For those of you who've taken patent law, you will know that there's a presumption of validity for patents. What I discovered in my historical research, and this was just by chance that I discovered this, was that this was drawn actually from real property law. There's actually a canon of construction for title deeds. You construe title deeds liberally in favor of the property owner, and there's a dispute over it. And long before you had peripheral claiming, you had central claiming. In the early antebellum era, when courts were asked to construe patent documents vis-a-vis potentially infringing devices, they adopted the canon that they drew from real property law that you construe a title deed because they had already analogized patents and title deeds favorably in favor of the property owner. This is the actual foundation and root of what we now call the presumption of validity. It is rooted in the actual conceptual linkage between patents and real property on interpretive grounds and viewing patents as tantamount to title deeds and recognizing the courts have to do the exact same things with respect to patents. They've always had to do with title deeds. They have to use all the terms, is this an or, an and, what's the meaning of this phrase, what's the meaning of the addendum clause. These are all probabilistic terms. And the reason why I'm going on about this is that this is my current article I'm writing right now is actually on the misuse of real property, by current IP scholars in evaluating the patent system. They constantly say we have to make patents like fences. Well, real property doesn't operate like fences. Real property operates in a very similar probabilistic way with very similar policy considerations at stake. And it always has, just as patent system always has.
Just the 15-second response, 30-second talk. I would dare say, though, that if we have a series of disputes over the scope of an easement, which happen a lot, fair point, that we are going to be loath to accuse the person trying to use this supposed easement being a pirate. And I think what we'd probably say is there's a legitimate dispute between a couple of reasonable people, and of course we'll decide who's right.
Actually, in the cases that teaching property and having read the property cases, in cases where people very deliberately breach easements knowingly and against the express statements of the serving tenement owners to the contrary, courts take very strong stances against them and use tremendous rhetoric in characterizing the ill nature of their behavior. Recall that trespass was called by the king, by common law, a breach of the king's peace. I mean, people who engaged in trespass were accused of sowing social disorder. And it's not a coincidence that one increases the scope of an easement beyond the bounds of the easement as created. It's deemed a trespass, and it's treated the same by the courts. And they use very similar property. When it's done deliberately, you're right. I think that piracy is a very strong term and should be used in the cases where people are knowingly or deliberately engaging in that. Because that's how it's used in real property. People don't say that a person who accidentally walks on someone's land is a pirate.
Okay, so another 10 seconds. Deliberately engaging in theft. You are correct that in the two big verdicts this past summer, the alleged infringers admitted that that they downloaded the music and it was
copyrighted. Court judgment, you have to say allegedly.
Yeah, right. Yes, you don't have to worry about defamation.
Yes.
But I'm not so sure that they would concede that it was theft. And in fact, one of the arguments that's being raised in appeal in one of the cases is that they didn't have an opportunity to present their fair use defense. So I think that's different when we talk about the probabilistic nature of the right. It's like the person saying, well, I thought in good faith that the scope of my easement was X. It's not that I'm deliberately going past the scope of my easement and killing your foxes, killing the king's foxes. I thought I had a fair use argument.
Although, I mean, I think you're accepting their legal arguments too much on the face of them because, yes, they're trying to legally rationalize their theft by appealing to doctrines that protect legitimate uses of property. Just like, the guy who murders his parents says, I did it in self-defense. We don't say, oh, well, he did it in self-defense, so we should do that all, even though he admitted to murdering them, we should, we need to give credence to a self-defense claim. And that he's an orphan. So I mean, the fact of the matter is people got on the stand and said, yes, I knowingly knew that they were copyrights, and yes, their lawyers talked to them and said, yes, but I don't believe the internet changes everything, stuff like that. At the end of the day, they knew they were copyrighted works, and they knowingly downloaded copyrighted works that they had not paid for. And just like in BMG versus Gonzalez, where the person said, well, yes, I downloaded thousands of copies of music, but I was doing the same thing you do when you go to the music store and you listen to the 30-second song. I was just sampling. And the court rightly saw that as a rationalization for what it was. They said, well, if you were sampling one, you wouldn't have kept them on your hard drive. And two, you can go to the music store, listen to the 30-second. That's a license that the music owners grant to the music stores for that purpose. And you don't need the download. You know that. And so, I mean, yes, are they arguing this on their behalf in the same way that people who are guilty of crimes argue all sorts of, or make all sorts of assertions of self-defense and vagueness and all stuff? Yeah, but I don't think that necessarily means you should accept it on its face value. I think you have, what I'm trying to say is, I think you have better cases than those ones. I think there are borderline cases, I agree with you, just like there's borderline cases for real property. I don't think you should be trying to defend Henderson and Ramirez, is her name Ramirez? The Minnesota woman, and then Gonzalez and those people, because those people, they're very hard to defend because their legal arguments don't match their factual admissions.
Yeah, but just like we don't call a person a criminal until they've been convicted of a crime, I don't know that we call someone a pirate until they've had a chance. Now, they've been found liable, but the argument is they didn't have a chance to present their fair use defense, just like, say, the defendants in the Sony case years ago, in which the Supreme Court said, well, no, time shifting is not just a pretext. Okay?
Yeah, although, but you make it sound though like, oh, well, they wanted to assert fair use. They wanted to assert fair use and they were shut down. The reason why they weren't allowed to assert a fair use claim is because it conflicted against their statements. When they said, I want to make a fair use defense, the opposing counsel stood up and said, they can't make a fair use defense when they have admitted deliberate, knowing infringement.
I'll ask one more question and continue to argue on the basis of that one. So, my question is for Professor Mossoff. I think Professor Opderbeck mentioned some law and social norms literature. I think the conventional wisdom of this literature is that laws which are very forceful and very great disparity from social norms are not so effective. This literature, especially down to Hans pieces, argue that gentle nudges are more effective. Now, clearly your goal is to enforce intellectual property rights, so wouldn't the enforcement be more effective without using piracy and theft rhetoric, perhaps only enforcing it when a great number of songs were downloaded, so people would think that only when you do something much more significant, you have committed a crime, and still not calling it theft because it does not amount to theft. Wouldn't, I mean, it doesn't piracy rhetoric really support your goal, is my question.
It does and it doesn't, because I agree with you that I'm a huge fan of the social norms work, especially the progress. The lobster games in Maine, Atkinson's famous study, the law with the order, law of all those things. In fact, social norms get started by studying and looking at actually property owners and how they step outside the legal systems to adjudicate disputes. And it's a very hard problem right now because the music industry is I don't tend to think of myself as a defender of the music industry. If I was ever to describe the music industry, I'd say I typically describe it as a bunch of Luddites who are committed to the production of innovative works. They are they've got a business model and a way of doing business that they have that they want to protect and maintain and secure against opposing competition and technological innovation. And I don't support that. I mean, the DVD was invented in the 1980s. The only reason why it didn't come in the United States until the late 90s was because the music industry convinced the US government to prevent it from coming in the United States. The Japanese had it since the 80s because they were worried about copying. Well, that really wasn't. That was their claim. What they were upset about was the fact that this was going to be a challenge to the CDs. And they had just moved to a CD manufacturing model, and they were now worried about DVDs. So. And they also sat on their hands when the internet came around. And they waited too long to address the internet. And a lot of social norms evolved on the internet that were counter to intellectual property. And I think that they really blew it in terms of the norms. Because now the norms on the internet don't necessarily reflect intellectual property laws. And that's a serious question. And that's how do you recapture that? Is a recapture the norms back into making them conforming with the law as you can, is a difficult question that I don't have to pretend to have the answer to, and I don't know if anyone does. I do think the MPAA, the Motion Picture Association of America, which kind of didn't have to worry about copying on the internet because until there was broadband, you couldn't download movies. So when that eventually came around, they looked at the RA and what the RA had done, and they are taking some different tacks that I think are much better, and I think that they're doing a much better job at trying to make sure that the norms evolve on the internet in conformity with their intellectual property rights. But it's a very, very tough issue, but I know that you can't recapture norms without the use of without the use of the terms that reflect the norms. And so you know, kind of, if they get up and they talk about balance and stuff like that, well, you should just have balance, and you just have to, for economic purposes and posting models and the economic analysis. People who are against copyright are here saying IP is theft. You are stopping me from using my computer, you are stopping me from speaking. They're using very heavily morally laden rhetoric on their side. This is about free speech, this is about my ability to think, this is about the use of my property, my computer, my house. And you've got to match that with rhetoric too. If you don't, you lose. Norms do not evolve through simple, calm, descriptive, economic or legal analysis. They develop in conformity with both. And I think you have to have both. But how you do it is a complicated way, and I think the RA really screwed it up. So I don't want to be perceived as a mouthpiece for the RA, who I'm not very happy with. But nonetheless, if you don't like someone's business model, which is really what people say, oh, they have a bad business model, that's not a justification for theft. You don't say, well, I don't like the way that cars are sold to auto dealers. GM really doesn't get all the money; it goes to the auto dealer. Well, that doesn't give you the right to go onto a parking lot and drive off with a Corvette. And if you don't like the business model, challenge it with another business model. And I think some people are doing that, and I think that's smart. I think iTunes, was a fantastic. It was the first step of a challenge of a business model, and Steve Jobs is great. He got the recording industry to jump on board with it, right? He got them to say, yeah, we'll allow pay for download service, and that's a step in the right direction.
I quick response. I agree with almost everything Professor Mossoff said there.
Wait, I have to say something else then.
But I would add two nuances to it. I think there is a point at which I think you don't try to recapture social norms because the social norms reflect a prudential or moral judgment of the people that the law is simply wrong. And that was sort of one of the ideas behind the quotes I gave from Augustine and Aquinas. That we have a long tradition in Western law that sometimes the law is wrong and sometimes people's norms show that. That conflict shows that. And I would suggest that around the margins of copyright and property, that's what's happening. The other thing I would say is that this problem of new technologies, we have to be sensitive to the problem of regulatory capture. And I think that the recording industry or the pharmaceutical industry, faced with the kind of challenges that I tried to mention, have a bunch of different options. And one option is to try and create new markets to exploit these new technologies, like iTunes. And by the way, I don't think iTunes would have happened if it weren't for Napster. So I think there's a
no, I don't think iTunes would have happened if it weren't for Napster decision.
Yes, true. But there's a creative destruction that happened there because of the illegal activity, right? Nor would the DVD have happened if it weren't for the Sony decision. So you can try and exploit those markets, or you can jump up and down and yell and scream about piracy and try and lobby for even stronger laws like the DMCA that put up higher and bigger fences. So my objection isn't to some fences. It's more to this process of capture. I also should just be clear to the record. I don't think it's okay. The law is what it is, so I don't think it's okay to just download music legally.
It's not legal advice.
Right. I'm not trying to either legally or morally justify people who knowingly violate the law. My suggestion is just that this tension suggests there's a problem with the law needs to change to deal with the problem.
Okay, so it sounds like you're saying that it might be too late, but maybe we should try to change the norms anyway. The big question for Professor Opderbeck now is there any, does it really matter that we have the rhetoric? Does it really cause any damage? So I think I should bring my question into several issues. First of all, does rhetoric matter? If it matters, do you think it affects the enforcement of legitimate intellectual property rights? Of what you said before, probably not. Or do you think the problem is that it affects the enforcement of laws in other areas? Is there really any spillover effect here? Because if there is some kind of spillover effect, then maybe if it's too late, we shouldn't risk and have these laws which don't change the social norms anyway. But if there's no spillover effect, then why not try it, as Professor Mossoff is indicating?
Well, partly that's an empirical question that I don't have data to answer, but here's my gut reaction. One way in which I think it matters is exactly the way Professor Mossoff mentioned, is we have corresponding rhetoric on the other side. I'm not a copyleft person either. I'm sort of in the middle of this. So you have rhetoric wars, right? The whole thing escalates. That causes social tensions and costs and other things that are, I think, really unfortunate and unnecessary when we could come up with a very reasonable and rational way through licensing or other things of dealing with these problems. So in that way, I think there's a cost. My gut also tells me that it does spill over into sort of a broader diminishment of the rule of law. I mean, in Leslie's book, he talks about speaking with the dean of Stanford Law School, and the dean of Stanford Law School is saying almost all the students coming into school today who are going to be sworn in as lawyers technically are criminals. Because I won't ask for a show of hands, but how many of you have downloaded a song that you shouldn't have downloaded? My 14-year-old daughter, on my computer, downloaded songs. I didn't know about it, and I'm thinking, I'm going to get sued by Korea because so no, she shouldn't do that. I told her not to do it, right? But because it's such the social networking phenomena and the internet is such an enormous phenomena, and we have this set of norms, it simply didn't exist in the 19th century in the same way. That in that sense, I think there is sort of an erosion. That just escalating wars of rhetoric aren't useful.
And Lessig is that, though. I mean, he's a master of rhetoric. I mean, he paints himself as, I'm just Mr. Balance, I just want this, but I mean, he'll call the recording industry Soviets. He refers to the music industry as sharecroppers. I mean, this is rhetoric, right? He's painting them as communist dictators or as as slave owners. And he's doing this purposely. I mean, it's rhetoric, and it's rhetoric because it captures a norm that he's trying to advance. So I think Lessig proves rhetoric doesn't matter. It carries norms, moral or otherwise, that motivate people, that drive policy. At the end of the day, we're seeing this in the healthcare. Rhetoric matters, and each side is vying for what gives them traction, and what gives them traction in the policy debates is not just the numbers. The numbers is framed through norms, through rhetoric.
So as someone who wants to enforce stronger rights, aren't you concerned that this is actually going to impede the rule of law in other areas of IP?
No, because as someone who does a lot of historical research, you get what's new is old again. I mean, what's old is new again. You say, oh, well, they didn't have these social networks in the 19th century. Everything's new. Everything's different now. Well, in the 19th century, they didn't have factories in the 18th century. They didn't have railroads in the 18th century. They didn't have mass communication through telegraphs. I mean, in fact, when Morse invented the telegraph, I mean, people didn't believe him that it would work. He actually had to go. His first client was the government because no one believed him that you could actually send signals by electricity over wires at more than a couple hundred feet. And he convinced Congress, so they were his first client. And you get every year, every era, it's different from the prior one. People are interacting and are interacting socially, economically, politically, in ways that were different than the prior era. So it's a truism to say, oh, things are so different now, so we have to rethink the whole model. I think my attitude, my general attitude is is that when as you have technological and social and economic changes that are vast, like we had in the 19th century, the 19th century was a vast challenge to the law and the political situation with industrialization. We don't remember it anymore because it was so long ago, but it was very radical. It's just as much of an upheaval as our digital revolution is now. And my attitude is defer to the people in terms of the owners of the stuff that they're creating and to the people they're licensing with, because they know the best value of it and they know what to do with it. And to the extent that they start changing other people's rights, then you can step in. But we've learned through history that handing power over to the government and to government regulators hasn't been such a good thing. Hasn't worked at all as an historical matter, and I'm wary of doing it again.
See, I want to say defer to the people who create it and defer to the people who use it as well. And I think that's the missing piece in this question about rhetoric, because intellectual property is not created just to be created. Even under Locke's labor theory, it's created to be used productively, not to sit on the field and spoil.
That's a slight. The analogy doesn't work. In fact, people recognize the spoilage analogy to IT very early, and Locke's point was literally, if you leave a walnut outside, it's going to rot. But ideas don't rot.
Well, they do, though, because the technology develops and it
develops
in different ways.
You're misusing the analogy. I mean, literally, the actual product disintegrates and is not usable anymore. That particular walnut is gone and is lost as something that can be useful in human life.
Right. So
ideas don't. So there is no spoilage with them as such. And in fact, the time limitation ensures that there's going to be no spoilage, because insofar as someone else wants to use it for productive purposes and they're being prevented from it, the 20-year patent or the life plus 90 in copyright ensures eventually that it will be used and won't just.
Yeah, well,
You can respond though to open the floor for questions.
Real quick. It's an interesting question for me because you're sort of touching on the difference between rivalrous and non-rivalrous property, right? So, and that's a common distinction that we make in intellectual property theory. My personal view is that distinction is overused because creative work and knowledge work always is done in the context of communities and societies. So there's a social dimension to it, a social rivalrousness to it. It's of course true that an idea doesn't rot like an acorn rots, but if an idea is not plugged into a social setting and developed within that social setting, and you can't have further creativity and further innovation based on that idea in a timely fashion, then in a sense it does rot. And so we can get into a big discussion about whether the 20-year patent term is too long, whether the Eldred case was wrong and the copyright term is too long.
Lost production opportunities are not the same thing as destruction. If you blow up a house, the house is gone. If the house can be used for better things down the road, that's not rotting. That's not tantamount to destroying that.
Okay, so now we're going to take questions from the audience. Yes?
My question is for Professor Mossoff. You stated a couple of times in your introductory speech something that along the lines like if you download music, it's theft, and if you download it intentionally, it's piracy. But outside of this context, both theft and piracy are intentional, and piracy in fact means something along the lines of theft or burglary on the high seas involving two vessels for non-political purposes. So my question is, other than being used as rhetoric, is there anything of the term piracy is how you're using it that actually relates to piracy outside of this context? It would make it like a reasonable term to explain.
I'm using it in the way the courts used to back in Chief Justice Marshall and Justice Story, in the taking of someone's profit. I guess you could suggest that perhaps there is a sense in which piracy is defined as a legal concept as someone who is outside the social order. So actually in the 18th and 19th centuries, if someone was defined as a pirate, that meant that if you caught them, You didn't have to give them due process. You didn't have to give them, you hang them by the yard arm. So does this suggest that maybe we could shoot, we can hang Larry Leslie by the yard arm? No, but what they were trying to capture was the sense of taking someone's profit. What pirates do is they steal stuff that's valuable to someone else and they're engaged in a productive enterprise, or they're doing something with something and they're taking their profit from them, taking advantage of the fact that the ship is out at sea. They don't have immediate control over it like you might have over your land, and in a sense that's what intellectual property infringers are doing, because they're taking advantage of the fact that since it's not rival or it's not exclusive, you can't necessarily keep an eye on everyone you might be using it. But don't make too much of the intentionality aspect, right? We say trespass is an intentional tort, but you don't have to literally be thinking in your head, I'm going to trespass or I'm going to be liable for trespass. It's actually not intentional in the sense, in a very real sense. You can mistakenly walk on someone's property and you're still guilty liable for trespass. Or you'd be guilty of criminal trespass for going onto someone's property. So I view it, the trespass, theft, and piracy terms in that context.
Okay. My view is that where the metaphor is most apt is that there are in fact organized crime rings that are engaged in distribution of especially copyrighted work, or in distribution of technology to break encryption. So for example, if you buy a card to break your DirecTV, in all likelihood the code and the card are provided by an organized crime network, just like the mafia. So in that context, it's much more like traditional piracy.
I have a question for Professor Mossoff, but it's I guess that question about your conclusions that you draw based upon the use in the 18th and 19th century of piracy. And I'd like to ascertain, I guess, a few predicates. When you talk about all these cases you went through, patent one side, but were you also looking at state courts, looking at intellectual property issues using based on state causes of action, or is it just strictly in the federal court system under the IP laws?
Well, there are no patent and copyright.
No, I meant just IP in general, common law copyright.
I was doing my work in patent law when I was primarily looking at cases, although I have done some small amount of scope research in trademark and trade secret, which are state based, and I have sections on that. Framing of those rights as property rights. In fact, the United States, again, took a very unusual tack in defining trade secrets as property rights. To this day, England defines trade secrets actually as a melange of tort and contract. But that's another article.
So if we can find ourselves talking about federal patent actions, it seems like you're discussing them as a property right and leaving it there. And you talk about the rhetoric, and one conclusion we can draw is that basically using this rhetoric because courts are experienced and functioning sort of as a glorified register of deeds. So hence they're using rhetoric similar to real property. But on the other hand, a question that I was wondering about a separate conclusion is the fact that you can alienate, sell, you have all these particular property rights doesn't really address the distinction between natural and vested property rights. And again, to go back, it seems like you're treating the intellectual property clause or that specific legal philosophy of the time really as sort of again the register of deeds, like the IP clause in the Constitution, to serve as a facilitator of these natural rights. But if you look at especially that year, the natural vested right dichotomy, how can we not reach the same conclusion that these are merely rights by virtue of statute? And so we're not going to take away from the possibilities of alienation those property rights, but they're certainly contingent upon the whim of the legislature.
I specifically addressed the inchoate versus coate or inchoate investment distinction, how it's applied in patent context in the article that arose from historical research. The article is called "Who Cares What Thomas Jefferson Thought About Patents?" Reevaluating patent privilege in historical context. And actually, I specifically addressed that. So thank you for asking that question. That was not planned.
I was worried about asking this because it would probably reveal that I didn't read
So you can go there for the further detail, but just as kind of a summary of this. a lot of people today have a very simplistic understanding of natural rights philosophy and how it works in political philosophy. They think of it as kind of a binary thing. You have your natural rights, you go into civil society, and the function of civil society is to secure your natural rights and destroy it. But it was actually natural rights philosophy, and particularly in its political philosophy, was very sophisticated and complex in the 18th century. Because they, for instance, they distinguished between what were natural rights, like life, liberty, and property, and civil rights were what came to be called privileges in the context of immunities and privileges, privileges and immunities. Article 4 of the Constitution, states cannot abridge other states' privileges and immunities, which they took from Blackstone. Privileges and immunities was a term of art. Immunities meant natural rights. Privileges meant civil rights. Because there are a lot of rights in society that you have to have in a just and properly functioning society that aren't natural rights. Like civil rights, or I mean like due process rights, right? Due process right can't be a natural right because the whole point of due process is that you get due process in the court of law. There aren't any courts in this state of nature, so there are no natural rights in due process. Contracts. Contracts are not natural rights. Natural rights philosophy in the 18th century. There are no contracts in the state of nature. There's no distinction between legally enforceable promises and promises. There were a whole slew of rights that they fit under the category of what they call privileges, and what we would call now civil rights, that they viewed as not natural rights, but flowing necessarily from the requirements of what does it mean to have a just civil society. And intellectual property, which was not a natural right in the schema, fell within this schema on the privilege side, meaning it was a civil right. And in a sense, it was a civil right enforcing a fundamental property right that only comes into existence and can only be enforced once you enter into civil society. Another example, some property rights are privileges. The rights of conveyance. There are no conveyance, there are lawfully enforced conveyances in the state of nature. The only natural rights that relate to property are rights of use, acquisition and use. If you want to have right of disposal, you've got to have civil society that's going to enforce that through the conveyances. Title recordation and the rights that flow from that, and the benefits that flow from that, like the canon of interpretation that you interpret deeds in favor of property owners. These are all called privileges within the framework of privileges and immunities. Now, the reason why I wrote my article is that a lot of scholars today go back and look at the historical record and they see courts calling patents privileges. And they say, oh, see, privileges, meaning special privileges, meaning grants from the government that they're just special, they're in fact against the common law of natural rights. Where in fact, they were using privileges and a lot of those usages in this special term of art that we no longer use. This privileges as a legal term of art is fallen by the wayside. We no longer have this context. Although if you still look at privileges and immunities cases running through the 20th century, they still talk about it in these cases. Another example of a privilege is a right to vote. There is no voting in the state of nature, but yet a fundamental requirement of a just society is you have to have a right to vote. Civil rights in this way, privileges in this way, they're justified by the policies underlying natural rights, but they're not natural rights themselves. And in fact, they used explicitly the inchoate versus coate, or vesting point, for patents. And they said the act of invention creates an inchoate property right that you perfect or vest by securing a patent. I found lots of court cases where they talk to patents in this way, which follows exactly the way they talk about property. We learn in property, first possession is the basis of property. No, what first possession does is first possession creates an inchoate claim to that piece of land that you perfect by securing yourself a title deed, because it's not legally enforceable as a legal property right until you have a title deed. And so this is where the title deed analogy actually had doctrinal bite for them, and had explanatory bite as a property right. Defined as, conceived of as a civil right in the same way that title liquidation requirements and formalities and conveyance requirements were conceived of.
We have time for one more question. Okay, so we actually have a reception now of food for which we supplied by the Templeton Foundation, and I would like to thank our panelists. Thank you very much.